Are voters who signed a petition to recall an elected official allowed to change their minds and signed another document asking to strike their names from that recall? Thanks for staying with us at 6:30. I'm Christiane Klein.
And I'm Brian Loftus, and that issue took center stage in Carson City today before the Nevada Supreme Court as attorneys argued over the stalled recalls targeting state senators Joyce Woodhouse and Nicole Cannizzaro. And Politics Now co-host Steve Sebelius has been following the recalls since the beginning, joining us live.
Well, Brian and Christiane, those so-called strike requests are at the very heart of this case. Then the recall backers say they're unconstitutional. They were created by the legislature. They're not mentioned in the Constitution, and they can be submitted for 5 days after recall signatures have been submitted. In this case, a sampling of the 5% of signatures initially showed both petitions were valid and could trigger special elections. But questions about the validity of those signatures and the number of valid strike requests led a Clark County judge to order that every single signature on each petition be reviewed. That review showed neither petition hit the mark. But recall lawyer Michael Wall argued today that the full review should never have happened.
What can't happen is after the petition is filed, the targets can take some other action to try to undo the petition. And that's what strike requests allow them to do.
But it's my understanding, even without the strike requests, they determined after the full review that in fact there weren't sufficient signatures, even if you don't consider the strike requests.
The problem with that's correct to a degree, Your Honor. The only reason it was sent back for this re-verification process to take place was so that they could apply these strike requests that shouldn't have existed in the first place.
Now, Wall also argued that there were errors in the full review of signatures and then that at least one of the petitions, the one targeting Woodhouse, might have had enough valid signatures to trigger an election. But he maintained that once the petitions were submitted and the sample showed enough valid signatures, an election should have been held regardless of any other consideration. Now, that sparked questions from at least two of the justices and brought a response from Woodhouse's attorney, Mark Elias.
I don't think it was inappropriate for a trial judge to do what it is trial judges do, which is to try to just get the facts. What is the actual number? And it would be truly an absurd result, as Justice Hardison said, that we were to now proceed with a recall where we know the actual number. I mean, if you take a step back, the objection coming from the other side, from my friend on the other side, is that we should remain blind to what the actual number of signatures were.
Now, the court won't rule on the case for some time, and even then we may not get an answer, and that's because the lower court found there weren't enough signatures in the first place, so justices may dismiss the case on those grounds, Brian and Christiane, and leave the issue of the strike requests for another day.
Just push that off.
Yes.
All right. Thanks, Steve.
Thanks.